court then reads subsection 60, subsection 4, subsection E, read with subsection 8, capital letter A, the applicant in his own statement in Exhibit A says he received death threats from even before he was a suspect. No evidence was led by the applicant or placed before this court or alluded to what steps he will take to now avoid that these death threats becomes a fact. The only fact placed before this court by way of argument by the defense is that there are now such threats from the already convicted person, but no evidence was placed before this court, and it is clear, even if a bail application is sui generis, the court must have evidence before it upon which the applicant shows why it is in the interest of justice, exceptionally so, that he be released on bail. I therefore find as follows. One, that the applicant has not shown that he will stand his trial. That the applicant throughout has relied on an affidavit which only states the bare minimum and he carries the burden on abundance of probabilities. The question now arises, and this was placed before the court by both the applicant and the moreover so by the state, that the interest of justice, especially because of the public interest in this case, not only stretching in the Roodepoort area or the Gauteng area, but nationally, whether the interest of justice as per section 60 subsection 4E is not sufficient, why the applicant should not be released on bail. This section reads as follows. Where in exceptional circumstances there is the likelihood that the release of the accused will disturb the public order or undermine the public peace or safety. And here it is stressed that exceptional circumstances must exist that show that the release of the applicant or accused will disturb the public order or undermine the public peace. If the applicant only wants to take the court into his confidence that he was threatened even before he was a suspect, whereas now he is an accused, the court cannot other than find that the applicant has also not discharged the onus to show that the public order and peace will not be disturbed. Regarding the fact that the applicant says he does not know the identity of any of the witnesses, the court just wants to remark briefly that the state does place before the court that there are witnesses that are willing to testify against the applicant in this case. However, if the applicant is released on bail, they will not be as willing to testify as the applicant knows them. The applicant knows their addresses. It is a well-known fact, according to the Shabalala case, that the contents of the docket, as well as an indictment, as well as a list of witnesses, will be supplied to the applicant once everything is in order and the case to be transmitted and transferred to the High Court for trial. And in the light thereof, the applicant's mere denial of knowing the witnesses is simply not enough. There was no application to force the state to say who these witnesses were. There was no, which most probably would in any case not have been granted, as the witnesses already fear for their lives. The applicant did not reply to the allegation by the state that there are other independent witnesses apart from the cell phone records and the video footage and the testimony of the convicted. accused at this stage. Therefore, the court finds that the statement of the applicant is not sufficient to show that there are exceptional circumstances why it would be in the interest that he be released on bail, and bail is refused. Court will adjourn.